Thank you guys for having me. Appreciate you being here. I'm looking forward to talking to you guys. I've been working with Cara and Teresa at PlebLab for a couple years now, and actually several folks who are working with, including as you can see the top builder ad, working with Timestamp and several of the other Bitcoin companies. So it's a really exciting area. Really excited to be able to speak with you. I'm going to dive right in. Just a little bit about me, in case you didn't know anything about me coming into this. Is I am a lawyer. I've been practicing for, it's a little dated slide. It's a little more than 25 years now, but I think I'll leave it there for a while. Just okay. 25 years sounds good enough. I don't know that 30 adds anything to it. Not that I'm there yet. So I practice technology law, and basically the easiest way to say it, I work at a boutique in Dallas that does work with technology companies. I'm sort of the transactional guy and the corporate guy there. Most of the other attorneys are either patent lawyers, trademark copyright, or other types of intellectual property, including litigation work, but I'm sort of the business transactional corporate guy. I'm also a professor of practice, which is just a fancy way of saying not full-time, non-tenure track professor at SMU's Cox School of Business. So I teach business law there, as well as entrepreneurial law, which is actually kind of a lot of fun. It's way more fun than business law is because it's a lot more clinical and practical. I'm also a founder myself. I've done a number of ventures over the years. In fact, that's how I met Teresa many years ago. Was with a prior venture that I had. One of the most recent ventures I'm working with is Ventac, which is something I hope to have a little bit of time to talk to you guys about, because it's a better way, I guess, to get access to legal counsel, kind of on a little more of interests are aligned between client and lawyer. It's a little more cost effective, I guess, is the way to say this. So hopefully you at least have you can check out the website. You can also, there'll be some QR codes at the end if you wanted to check out Ventac as well. That's typically how I work. Mostly I worked with PlebLab and some of the other ventures that have come through the PlebLab system. All right, so diving right in. And as I mentioned to Carr offline before, he was asking, so how long do you need for this? And I'm like, well, I can do it in 20, 30 minutes or 3 or 4 hours. It just depends on what you want to talk about. But these are the 8 elements, and I could have picked 12. I could have picked 15. And this is not that every single startup goes through this. I'm aware of that. But I've been doing this. I've been working not just in the startup space, but in the business space, particularly in the startup space. Lately, these are the issues that I see often that cause conflict, cause challenges, and in some cases can really mire down an emerging company to the extent that it dies. And I've seen it happen. Unfortunately, some really good ideas, really good concepts, and people, things changed, something happened, and so these are the things I want you guys to at least have in mind. So at least these startup ideas or these startup challenges, maybe you can avoid, and that won't hamper your ability to grow your company. First and foremost, the most obvious one, not having a legal budget. I mean, particularly a technology-based company, you really, all you are is ideas. Your technology, your intellectual property, understanding what your business is and what it's worth, getting the right kind of documents in line, corporate stuff, as well as intellectual property protection and contracts between the founders, contract with investors. All these things, they need legal counsel. You need somebody you can rely on. And as much as we love AI and ChatGPT, it's not there yet. I don't know that it ever will be. It's definitely gotten better. But I use it in my own practice sometimes. I use it to create not so much legal documents, but I use AI regularly to create posts and things, and even web pages and stuff. But whenever I deal with AI and ChatGPT and things like that for legal projects that produces something that is deceptively wrong, and it looks good, it sounds kind of good, kind of like a lawyer, but unless you are a lawyer looking at those documents and you realize how erroneous it is, you might be, have a false sense of security with it, which is the worst thing you can have. If you're not getting legal counsel, you kind of keep your head down. Right. But if you're getting good legal counsel, great, you move forward. But when you think you're getting good legal advice or you got good legal documents, when in fact you don't, that's a very dangerous position to be in. So one thing that, as you budget for everything, nobody wants to budget for stuff like taxes and legal, but it's the reality of it. You need to have some aspect of your budget that is dedicated to getting that counsel. And it doesn't have to, you don't have to get everything done at once. The right kind of lawyer, which leads me to the next one, the right kind of lawyer that understands what you're doing, that works with companies like you, will appreciate the limitations of capital, perhaps, particularly in the earliest stages, and will help you prioritize those projects. Not everything has to be done day one, but some things make more sense if they're done in a certain order. So, so not having a legal budget is definitely a flaw. Have some budget. Don't need millions of dollars necessarily, but you will need something, and it generally will continue to grow as your business grows. The wrong lawyer refers to a number of different things. It could be, someone that worked at a large firm. You went to college with them, or they're a cousin or something. And while large firm lawyers, I've been at a large firm myself. There's nothing wrong with them, except they're not necessarily great fits economically for a lot of startups. Most startups, most large firms, their economic model of the firm is based on larger companies. They don't want to just do a little bit of work for a company. They want to do a lot of work for a company that has a lot of work. Not $5,000 or $10,000 a year in billings. They want millions of dollars in billings. That's how partners become department heads and managing partners and so forth. But also the practice areas that the lawyers are working in. So if you're dealing with somebody who's a specialist in patent law or intellectual property, that's great. And you may need that lawyer, but that's not a business lawyer necessarily. And you're somebody who does only Bitcoin law or only financial regulations and that sort of thing. That's great. And they're probably a useful resource, but that's probably not the only lawyer you're going to need. If you had to have one lawyer, it should be someone with a broad-based business law and with a good network, and someone who works with startup companies, works with small to mid-sized companies. And what's great though is they don't have to be in Austin. They don't have to be in Texas. They don't even have to be in the US. They need to be US trained and have US experience, but they could be anywhere really. And so you do have a lot of options now. But getting the right lawyer, the right legal relationship isn't a one size fits all. Not everybody should go to the same lawyer. They're depending on your size, your economic limitations, your priorities, what you need, and just the working relationship that you want to have with a lawyer. If you're from a big company and you're used to working with lawyers, then maybe you'll seek out a different kind of counsel. If you've never done this before, then you need a lawyer who is used to working with people who've never done something like this before. It is different. I like to refer to working with entrepreneurs as dealing with the chaotic awesomeness of an early stage venture, and many lawyers don't like that. We're as a people, we're risk averse, right? And all you guys do is create risk. You make a lot of risky things, and that's how you create disrupt things, right? You create a lot of risk, and our job is to help you manage it. So you need a lawyer who's familiar with the environment and is comfortable with that sort of dynamism, that's constantly moving, constantly flowing. And they also have hopefully got some experience working with, I won't say, somewhat novices in the legal world, to where you don't always know how to use the lawyer. The lawyer needs to teach you how to work with them. And I time permitting, I do have a couple of recommendations on how to find a lawyer and how to work with lawyers here in the next couple of slides. Moving on. Talk about especially the earliest stage ventures. They go to an incubator or an accelerator. They go to some startup week things, and they start talking to people about their how they structure themselves. And these are people that are 2-3 steps away. They're getting their seed round. They're getting millions of dollars maybe, and they've got multiple layers of different shares of stock and all these complex management things. And the truth is, you don't need that to start out. Not everybody needs to be a Delaware C Corp. You can be. There's nothing wrong with that. But if if you've been paying attention to what's going on in Texas, Texas is quickly becoming a corporate hotbed. And not only do we have more Fortune 500s than just about anybody else, including some of the biggest ones that are moving here from places like California and New York. But we're going to get our own stock exchange now. We're moving toward that. We'll have the Y'all Street, TXSE. And we have a number of other things. We've got a great environment, as you guys probably already know, for business, low regulation, low tax environment, reasonable cost of living. So, another addition to that, as far as promoting Texas as a place to found your entity, that's getting you away from Delaware or California, is that Texas now has its own business courts. Which is one of the things that set Delaware apart early on, is had a special court just for corporations. That's one of the things that made corporation formation in Delaware very attractive. So, but if you form in Delaware and you're based in Texas, well, you have to register in Delaware, and you also have to register in Texas. That in and of itself is a complexity. I'm not saying you shouldn't be a corporation. I'm not saying you have to be an LLC, or you can't be in Delaware, or you must be in Texas, or whatever. I'm just saying that overly complicating your structure right out of the gate is just a recipe for disaster, because if you set up a structure that's complicated, first of all, it costs more. And secondly, if you're not used to managing a complex structure like a corporation, you might not be acknowledging and following all the formalities that corporations have to follow. And so when you do get ready to take on investment from the outside, not some friends and family or something like that, but somebody who's a little more sophisticated, they're going to look at your corporate records and see it's just a dumpster fire, right? That's going to be a problem that then you're going to have to clean up. It might threaten your deal, or it might get you less of a good deal that you want. One thing to keep in mind is, even if you start out as a, say, Texas LLC, and you want to become, because you bring in money, you're not, now we want to be a C Corp. Now we want to be a Delaware Corp, or maybe we want to be a C Corp in Texas. You can change that. And there's a number of ways that you can convert from a Texas LLC to a Texas corporation, or a Delaware LLC to a Delaware corporation, or a Texas LLC to a Delaware corporation. All those things are possible. You can do a conversion, or you can just set up a new entity and then roll the assets over. Sometimes I've done it both ways for companies that, when they got to that point 2-3 years down the road, that was a much more feasible way to do it. And yet in the early days, when it was just them and a couple of co-founders, it was just a little less complex and easier to comply with formalities, and therefore there was less cleanup to do when the investor came in and they started doing their due diligence and looking at the records and things. So I'm a big fan of keep it simple. Keep it as simple as long as you can keep it simple, because you don't really know what that big equity group, venture capital, whatever, what they really are going to want. They may want preferred shares, and you don't have a structure of preferred shares. They may want preferred shares that have certain rights. Well, if every right that a class of shares has got to be listed in the corporate charter, so that means you're going to have to amend the charter anyway. So I say keep it simple, and then when somebody comes in with the ability to write a big enough check, okay, if that's what you want, well, then we'll do it. Or you decide not to if you don't want to. But keep it simple until it's time to not be as simple. That's just, again, it's all these things are just general guidance and, a little bit of overgeneralizations, but these are things just to kind of keep in mind. And so I see companies that try to be a one size fits all, and they end up with a structure that they don't follow. And there's this other thing. It's on the outside, but it's a very real threat. It's called piercing the corporate veil. One of the benefits of an LLC or corporation is limited liability protection. Well, if you don't act like the entity that you're supposed to act like, if you're a corporation, you don't have board meetings that you document, you don't have shareholder meetings, you don't have bylaws, you don't have all the records that a traditional corporation should have, then a court could possibly grant a creditor, someone who wants to go after your personal assets, they might let them do that because you didn't follow those corporate formalities. So the less complicated the entity structure, the less formalities you're going to forget to follow. The next one I have on here is copying contracts from the internet. Well, buying them from Rocket Lawyer, or just going on to some other company's site, or I guess now I should probably add ChatGPT. All right, and all these kind of go together as useful, deceptively legal. They may look right. They're probably better than nothing, as long as you know that they're basically just better than nothing, and that's it. They're not necessarily what you really need. If you don't have a legal budget, well, then you're going to end up copying stuff from the internet. If you got the wrong lawyer, probably you're going to copy stuff from the internet. So they kind of all go together, right? But I often will look at I do a lot of license agreements. I do a lot of terms of use and privacy policies for my clients that are in the app space or software. They have websites and software programs and things that they're licensing. And so I don't necessarily know every industry. And so, but I know licensing, and I know license agreements and that sort of thing. But the nuances of an app that is in the bank care space or in the Bitcoin space, these various apps or programs can have their own special niches that are outside of maybe my expertise as a general technology lawyer. And so I often will ask a client, hey, do you have some competitors? Do you have some people in your space that are ahead of you that are doing something similar? Obviously, you're doing something a little different, but do you have something? And I'll get a list of these, and I will go look at their terms of use. I'll go look at their privacy policy, not because I need to copy the whole thing, but I want to see what are the nuances, what are the things that I can tell are industry specific, and that's what I integrate. But when someone who's not a professional, an attorney, goes and just grabs this stuff from another site, what you may be getting is a couple things. One, the other site might not be very good. They're just because they may have copied it from somewhere else. More often than not, that site may not reflect all the things your site is doing or your app is doing, and therefore it's going to treat it incorrectly, right? It's going to you're going to have language in there that's irrelevant or that's just straight out wrong, particularly in the case of privacy policies, because every app has different things they do. Every software program and website does things a little bit differently with the way they handle data, cookies, and everything else. And if you're copying someone else's, it doesn't necessarily reflect what you're actually doing. And so one of the easiest ways to violate a privacy policy is to not follow your own privacy policy, right? And nowadays, privacy policies are so driven by regulation. They're not, they do back in the good old days, as my kids like to say, in the 1900s, when I first started practicing law. Privacy policy was a contract that nobody read. So you would just, on your website or on your app, you would put it, it's very one-sided. We can do what we want, nothing you can do about it. Well, that's all changed. Now we have regulations that tell us you have to be transparent with a lot of things. You have to give people the right to opt out of certain things and to check the information. And so it's flipped. And so you have to disclose what you're doing with the data, how you're collecting the data. And so just copying somebody's, whether it's a rocket lawyer, general cookie cutter kind of thing, or LegalZoom or whatever, or it's somebody else, a competitor site, just taking that information directly is going to be, could be very problematic for a number of reasons. Moving on to the I guess is the fifth error is inadequate founder agreements. If you're in my SMU classes at the Cox School of Business, you would hear this sound and cringe because I say it so often. When it comes to writing contracts, when it comes to arrangements, relationships, good fences make for good neighbors. Okay, and so everything between the founders early on and every partner and vendor and everything else that you're working with, particularly things involving equity or creation of intellectual property, they have to be clearly defined in written agreements. They're often not, because you're working with people you trust, that you like, and that you're friends. That's great, and you should only work with people you like and you trust. But the job of a transactional attorney or a legal counsel is to make sure you stay that way. And the best way to do that is to have a good fence around the relationship. And when I say a good fence, I didn't say strong fence. I say tall fence. If you're good neighbors, you don't need a real big fence. The whole point of a fence, of a good fence, is just to demarcate the property lines. What's mine? What's yours? What do I owe you? What do you owe me? That's really all you need. You don't need, it's not about a bulletproof contract. It's about a clear and concise contract. I often say the dirtiest word in transactional law isn't one of those 4 or 5 letter words that you might hear on a rap song or some action movies. The dirtiest word in my world is ambiguity, because ambiguity leads to disruption, leads to disagreement, leads to broken relationships, and leads to litigation. So we want to avoid that, and the best way to avoid that is to have those fences, those legal documents, especially between the founders. Giving away equity. Now, I know that early stage ventures don't have a lot of cash and they don't want to take on debt, and it's hard to get debt anyway because they don't have cash flow, because maybe they haven't started making money yet, right? You may be pre-revenue by a while. So you think, oh, well, I'll just give some equity to this software developer. I'll give some equity to this person. I'll give, I want to bring them in as a co-founder and give them 20% of the company. That's fine. There's nothing wrong conceptually with that. Okay. Equity is an asset just like anything else that a company can have. But once you give it away, it's gone, right? It doesn't come back. And so I generally advise my clients that nobody who comes into a company gets equity, just gets it day one, unless they're writing a check for it or they're bringing something of value like patents or something. In other words, they've already given you the value. They're giving you the money, or they're giving you the assets or the brand, or they're bringing their company over. Okay, then they get their equity right then, sure, or most of it. Now, if you're bringing in somebody for equity, for services they're going to provide, whether they're going to develop your app, they're going to serve on your board, whatever, that should, their equity grant and the vesting of that equity should coincide with the resources they're providing you, right? If you want somebody to mow your lawn every day for the next 3 years, you don't pay them today for the next 3 years. You pay them as they mow the lawn, right? Or at some intervals, maybe once a month. Otherwise, they have less incentive to do it. And what if you bring in this co-founder and it's not working out, and they take another opportunity? And it happens a lot of times. You have a great idea, you get all excited, and they start working a little bit, and one person out of the team of 3 gets a new job or moves or gets married or gets divorced or dies or whatever. And and their equity is still there. They still have it. And you really need someone else to come in and take their role, to be that CFO, be that CTO or whatever, or COO, that other co-founder. But you don't have the equity to give them now. So factor that in. How do I get that back? So that if you do give the equity up front, then your founder agreements need to give you a chance to be able to claw that equity back if something happens too soon, like if they leave within the first year or 2 or 3, or they don't deliver. Ideally, though, it's the other way around. They come in, you give them an agreement that says, if you do this, this, and this, you're going to get this equity, and this equity, even if it's just, hey, we'll stay here over a certain amount of time. And this includes board members, advisors, as well as co-founders. So I'm a much bigger fan of things like options, which is not equity. It's the right to buy equity, and it can vest too. So if you have a board of advisors and you have a mentor and stuff that you want to encourage to help participate in the company, maybe they're industry, they're really well known in the industry, or they're just a really experienced entrepreneur, and they could give you some advice. Well, granting them options to equity, whether it's stock or LLC interest, or whatever your entity is, can be a really valuable tool. It's a way to reward them for helping you out. But even that needs to be structured. Hey, you're going to get this many shares or this many units, but they're going to vest this way every quarter, every few months. And I highly recommend, particularly with the board of advisors, which is not an official title, right? You just call it's a mentor, a coach. They're not on the board of directors, where you have built-in fiduciary obligations to the company. Officers have built-in fiduciary obligations to the company. Advisors do not. So there's nothing stopping an advisor from taking information you give them in a consultation and competing with you, sharing it with the world. If they give you an idea, a solution to your problem, do they own the intellectual property they just gave you? You could clarify that with an advisor agreement that's really clear, that says, hey, you're going to agree to keep this confidential. You're not going to compete with us. You're going to do this. And if you do all this and you participate, then we're going to give you these units, or we're going to give you these options. That's an incentive for them to sign that agreement. So now you do have confidentiality protection and some intellectual property ownership clarification. So that's also very important to do, particularly with advisors. And that leads into this idea of not correctly securing their intellectual property. The one and two biggest problems I see with startups is, one, there's a misunderstanding that, hey, I'm a founder of a company. I'm an owner of a company. Therefore, when I create IP, the company owns the IP. That's not true in most cases. That usually the inventor of a patented device or a patented method or whatever is the owner, not the company that they own. Certainly with writing code and developing images and everything that's copyright protected, that is owned by default by the author, the creator, not by the company. So even if you're the sole owner of a company and you create the code for this company, the company doesn't own the code, you do. You have to transfer that. So understanding that being a founder doesn't automatically make the company the owner of the IP. Simple solution: have a founder IP agreement. Boom. Then when they do create it, it's owned by the company. That's real simple. The other biggest issue when it comes to not securing IP, especially for early stage ventures, is not truly appreciating what IP is. Intellectual property isn't just the software code for your main product. IP involves copyright, trademark, trade secret, and patent. Now, not everybody has patents, but most everybody has the other three. You got some kind of copyright, even if it's just your website, even if it's just your logo, even if it's just some of the content, even if you're and obviously your software code. And then everybody has trade secrets, algorithms, processes, anything confidential that makes your business valuable. Everybody has trade secrets. And of course, trademarks. That's your logos, your brand, your slogans, all those things. So every business has these, but not every business truly appreciates it. So one exercise that you can do is to create an inventory. Just brainstorm. Okay, get your 4 categories, get 4 buckets, have a list. It's trademarks, trade secrets, patents, and copyrights. And then once you need to understand what these different types of IP are. But when you do, then you can go through and make a list. Okay, what do we have that's in the trademark list? What do we have that's in the trade secret list? Particularly those of you like yourselves that are in the apps or software space, regardless of what it does. Many of your products are essentially software products, and software is a quirky asset, because to truly fully protect a software asset, you might have to actually deploy all 4 types of IP to protect it, because some parts of software are protected by trademark, like Microsoft Word or Windows or whatever. That would be trademark, branding, slogans. Some are protected by copyright, like the code, user interface, things like that, look and feel, website, content, text, pictures, images. That's all copyright protected. And then you got trade secret, which would be your algorithms, your databases, anything that's not publicly visible that makes the software work, and the data that's produced from that. And then patents, where that's the one that you may or may not have, but you could be a patent on the software, or maybe if it interacts with hardware. So to truly fully protect your intellectual property in a software or app-based product, you have to look at it holistically. And this one you may not be thinking about, but because you're a startup. But I mean, a succession plan is important for every business. And succession doesn't just mean, hey, how are we going to exit? Are we going to go public? Are we going to sell to a bigger company? Of course, you don't necessarily control that, but you should at least have an idea of what you want to do. Because if you got two other founders and there's three of you, and one of you wants to go public, one of you wants to give it to their grandkids, and the other one wants to sell 5 years from now, you're just waiting on a problem that's about to happen. Just at some point, because y'all are going to have a conflict about which direction to take this company. So in addition to long-term succession plans, you also need to think in the terms of, look at yourself and your founders. As you grow and your business becomes more of a resource for not only your clients, but your employees. It's something people rely on. Now you're responsible for those people. What happens if one of you dies? What happens to that stock? What happens to that role they had? What happens if one of you just wants to leave? Are there mechanisms, going back to the equity structure, are there mechanisms for clawing back that equity? If that founder leaves when we're still in a very early stage, or part of our development. So having an idea of, I may not be in this company a year from now, 5 years from now, 10 years from now, or you may not be. What are the mechanisms for that? Again, you could figure it out when it happens, which generally doesn't work out real well. Or you can think it in advance. Remember, build that fence, that good fence that keeps everybody good neighbors. Now, that's just kind of a fly through of some of these key issues, but I do want to give a couple of pointers, because I feel remiss if I don't give you a couple of tips on how to find a lawyer and how to work with lawyers. First, when you're looking for a lawyer, know what type you need. Now you can be, think, I need a trademark lawyer, I need a patent lawyer, I need a business lawyer, and you can be that and go out and find all these people. Or you could find a good lawyer or two that are kind of doing some of your work, and then rely on them, because the best way to find the right lawyer for anything, or the right professional for anything, is to rely on, leverage those relationships that you have with existing lawyers or existing professionals that you work with. So in trying to find that lawyer, the best place to go is trusted advisors, right? If you have a banker, if you have an accountant, or even a friend or family member who is a lawyer, even if they do family law or they do criminal law or whatever, guess what though? They went to law school, and they went to law school with a bunch of people who are now lawyers, some of whom might be working in the startup space, some of whom might be business lawyers or patent lawyers. So these people you trust, these people you do know, particularly if they are attorneys or they work with attorneys regularly, that's the best place to start and leverage that relationship. Next, after that, I would go startup groups, accelerators, things like PlebLabs and groups. Talk to the community, people that are doing what you're doing. If they've got a lawyer they like and they're willing to refer them, that's a great resource there. Most people, though, the first thing they do is they Google up, I need a trademark lawyer to Austin, trademark lawyer to Dallas or Texas. Now, you're going to get a list of lawyers who ostensibly do trademark work, but that doesn't necessarily mean they're the best or they're the right fit for you. That just means they have good SEO, right? And that they know how to get on Google. So, but that is an option. Now, if you do find yourself in those online resources, there are some ways, and you find a lawyer you think you might like. The first thing I would do is go to their website. Okay, if you're looking for a patent lawyer, or you're looking for a corporate lawyer, and let's just say a business lawyer, just make it simple. And because you have specific needs in your with your app and things like that. So you find a lawyer on Google, go to their website, look at their firm. Is it a big firm? Is it a small firm? Look at that individual lawyer. What does it say in their bio? Do they say they do a lot of technology work, or do they mostly work with real estate? Do they mostly do litigation? If they're mostly litigation, they're not a transactional lawyer. So that should give you a little insight into the kind of lawyer that maybe they are and they aren't, just because they advertise that they do trademark work. And then you can do some outside research, do a little recon. There's a couple of sites out there you can go to just to check, and they do different things. Avo.com is kind of like Yelp for lawyers. It's there's ratings, there's client reviews. They even have a score. The highest score you can make is a 10.0. 10.0 is a good thing, or the closer to 10.0 that they are, that's usually a good indicator. They have a good standing in the industry. You could look at maybe some of the client reviews. Everything, again, taken with a grain of salt, but you can't buy those reviews. You can't buy those things. They have to come from at least a couple of clients that like you. Super lawyers is just a list of lawyers that each state has. It's by subject matter. So first of all, if you find a super lawyer that's listed in the technology transaction space, well, hey, not only are they respected by their peers because they've been selected as a super lawyer, and that's usually only about 5% of lawyers in each state are listed as super lawyers. But they also tells you, hey, they're in technology transactions as opposed to litigation. So don't just look at the fact they're on the list. What list are they in? Are they in an area that's relevant for what you need? Lawyers.com is the digital version of what used to be the old original lawyer directory called Martindale Hubble. And it was a lawyer directory. There was a big old set of books you would have to buy to be in the directory, that had every lawyer in the United States, pretty much, that wanted to be in the directory. And so if I'm in Dallas and I have a client that needs an employment lawyer in Los Angeles County, I could go to the book and I could look that up back in the olden times. Well, now it's online. Now they do, in addition to have a lawyer search online, they also have a rating system. A or B is, there's two letters, A, B, C, D, and then there's V. V just has to do with their ethics. So V is good, is the second letter. You always want to be V. And then you really want A. A means the top most experienced lawyers. B is okay. B means they're probably good lawyers. Maybe they're younger and they don't have as much experience, but they're probably really good. So AV or BV, AV being the best. Last but not least, Texas Bar. If you're looking for a lawyer in Texas, go to the Texas Bar website, type in that lawyer's name, and you can look and see, are they licensed? Are they based in Texas? How long have they been licensed? It has the date they were licensed in Texas. And then at the bottom, it'll tell you if they have any disciplinary history. So if there's ever been any issues with ethics or challenges like that are public, that would be there. What you want to see is no disciplinary history. That's the number one thing you want to see. But it is worth checking and make sure they're actually licensed attorneys. Again, the other things I just want are more about just kind of getting into once you find a lawyer you like. Just understand that law firm economics, big firms really work well with bigger clients. Not everybody needs to use, the firms out of the valley. Not everybody needs to use the biggest firms to do everything they need. Occasionally, you might need to bring those guys in certain situations, litigation matters, or maybe a series raise or something like that. But you probably can work with a little more cost-effective legal counsel, smaller firms, boutiques, even solos in some cases. Engagement is your relationship with the lawyer. That needs to be in writing, okay? And don't work with, I will just say this, don't work with a lawyer who doesn't have a written engagement letter, okay? It's just not good practice. I mean, the lawyers even follow their own advice, right? Have a good contract. Good fences make for good neighbors. So you will have an engagement letter. You should sign with it. Even if it's very basic, just outlines what their rates are going to be, what they're going to do for you, some things like that. Now, when you want to engage my firm, we have to run a conflicts check. So we cannot represent you and somebody you are also working with on the same matter or in a litigation matter where you're fighting each other. Kind of makes sense, right? So lawyers, the first thing they'll say is, hey, I got to run a conflicts check and then I'll send you an engagement letter. That's nothing personal. That's just what we do. We have to do that. Now you set up with that lawyer, you set up a meeting with them, you want to hire them, and you want to talk to them. Now remember, your conversation is attorney-client privilege, even before you hire them. Okay, if you're seeking out legal counsel from them, that is a protected conversation, provided it's just you and that lawyer and you and your company. You bring in an outsider like your CPA or somebody, that breaks confidentiality. Okay? Now the lawyer will try to keep it, but we're not legally protected by it anymore. We can't just say no, attorney-client privilege. But in addition to because of that attorney-client privilege, don't lie to the lawyer. Don't hide bad facts. If you know you're about to get sued by these guys, or that one of your partners came over from a competitor, and that partner that you got now that's working for you probably brought some trade secrets over, don't hide that, because it's going to come out in the lawsuit or whatever, and your lawyer needs to know this so we can prepare for it. We're much better at dealing with things that we know about. Give us time. Don't let us be surprised by anything. That doesn't work out for us. It definitely doesn't work out for you. But remember, don't hide negative information. Don't lie. Definitely mislead the lawyer. You are protected. Even before you've officially hired them, those initial conversations, seeking them, or even those are protected as well. All right. And last, this is just a general guide for how to work with lawyers. I call it the BDD. budget, deadline, deliverable. It keeps everybody happy. Okay, communication and communicating expectations is very important for me as a lawyer. You know, most of my clients are not competent to evaluate how good I am as a lawyer. They don't know if I'm a good lawyer. I mean, the contract is a contract. They know the results that we get, but I can't control those. A lot of times, facts, people's tendencies, strategy, whatever. No matter how good of an attorney you are, you're kind of stuck by that. So what people evaluate me as a lawyer on is, do I deliver what I said I was going to deliver, right? Did I charge what I said I was going to charge? Did I turn it in when I said I was going to turn it in? And so it's on me to manage that expectation, but you can do that too, because not every lawyer is good at this. And so I always say, never get off the phone or leave that office with that lawyer, given the green light to do something, unless y'all are both very clear on the BDD. What is the budget? What is the deadline, and what is the deliverable, right? What's the budget? And that could be a number of hours I'm going to spend or how much it's going to cost. What's the deadline? Is this tomorrow? Is this next week? Is this a year from now? And then the deliverable, are you just going to send me an email? Or are you going to file something for me? What does that look like? Okay, what work product is coming out? So just keep that BDD in mind. And I will say this, in the last 25 years working as an attorney, the situations where I've not gotten paid or I had a client that was not happy with what was going on, it never really had to do with the outcome of the matter. It never had to do with whether I did a good job. It was that there was an unmet need or an unmet expectation that I didn't manage. I didn't anticipate what they were thinking. And so, for example, you come to me, you say, hey, I want to get my app on the App Store, and they say I need a privacy policy. And I'm like, great. And you think in your mind, you don't tell me this. You think, it's probably what, $500, right? That's what I've seen, I've heard. I hear a little bit about what you're doing. And in my mind, I think, okay, this is not super bad. It's but I think it's going to take 4 or 5 hours. And I think it's going to be about $2,000, right? I don't tell you this stuff. And then I'm working on it. I get you the privacy policy draft to you, and you thought it was going to be something I'd do that day. I planned on, hey, I'll get it to you by next Friday. Well, I get it to you on Wednesday, and I end up billing $1,500. In my mind, I got it to you 2 days early and about $500 less than I thought it was going to be. Well, what are you thinking? Well, he's 3 days late. Man, $1,000 more than I thought it was going to be. And again, we're not talking about how good is a privacy policy. We're talking about how did I manage those expectations. So to avoid conflict, if your lawyer's not doing this, you do this, okay? And this also works in the real world. I don't care if it's somebody painting your house or if it's somebody working for you, software developer, whatever. What's the budget? What's the deadline? What's the deliverable? As long as you're on the same page with that, there's very little chance that you're actually going to have that dispute that leads to a broken relationship, right? I do want to leave with just a couple of slides. I can share this with you as well, but I mentioned that VinTech is kind of a new creature. I won't say how new. It's been around for a little while now, but I'm starting to kind of out there. And this is how I work again with PlebLabs and some other folks that I've met through PlebLabs. It's a new way of working with lawyers. It's a lawyer by subscription, legal counsel, legal forms, some access to documents, and some 200 something forms that I created or I've worked with over the last 20 years or so. Most of which relate to LLCs, corporations, people in the technology space. So there's probably a lot of good resources there. And the way it works is there's 2 models. There's the core model, which is just 2 legal consults a month by Zoom, and you get unlimited access to all the forms. And then if you need legal work and it goes to my law firm, and every hourly rate at my firm, not just myself, but even the patent lawyers and everything else, you get the premium rate discount. So you get the same rates we give to, I won't say names, but there's some people that you might have seen on Shark Tank that we do work with, and they get the big discounts, right? Because they give us all this volume, but small businesses don't, because let's be honest, as much as we love you, you're kind of a pain in the ass, right? Because small little project, we got to do set up the files, get an engagement letter, all this kind of stuff. And, so the smaller companies don't get the discounts. Well, if you go through VinTech and you end up in my firm, you get a discount on all your work that's done by all the attorneys there. So that's the core model. It's month-to-month subscription, paid by credit card, just boom, boom, boom. And you get those 2 consults. And no, they don't roll over. So it is an incentive for you to use them regularly and get to know and stay ahead of legal issues, because sometimes you can deal with a lot of stuff with just a conversation. And then as of December, just a few months ago, I rolled out VinTech Plus, which is everything that VinTech Core has, but it includes actual legal work. In addition to the consults, you can actually get 3 hours of contract review, LLC documentation, governance, clean up your corporate documents, stuff like that. Now, obviously, it's more expensive because you're getting legal work. But just to give you an idea, my rack rate at my law firm is nearly $700 an hour. That now discounted down by 25%, that's still $495. But if you can get 3 of those hours plus 2 consults, you're effectively getting 4 hours of my time for a much more discounted rate, right? So that's the QR code will get you that if you want to scan that, or just go to myventech.com. And last, I just want to leave you all with a free gift. Is I've got, if you go to the Ventech site, and again, you can scan in there or go to myventech.com. If you scroll down at the bottom, there are some different ebooks that I put together, transferring intangibles, basically buying and selling, a technology-based company, e-commerce handbook for legal issues. If you go international, there's I taught international business for 20 years at Baylor Law School, and that book is an adaptation of my textbook that I created. And then negotiating and drafting software development agreements. These are all free books. All you do is you put in, I think, an email address, and it gives you a download. And these are PDF books, no charge whatsoever, no obligation. You don't have to sign up for Ventech or anything. But that's it for me. I will tag out now and let Carr step back in and cut off the recording in case you. Now, I do want to warn everybody, though, that even though you are talking to an attorney, you're in a public forum. So don't say anything super secret that you don't want other people to know about, or be more hypothetical. And any recommendations I give are just general educational guidance, not legal advice, clearly, because this is, everything's based on a lot of facts that we won't be able to go into here. But I do appreciate your time. Hopefully you found some of this information useful. And I get this point, I will we'll let Carr step back into the stage, and I'll make this smaller so I can see you guys if I need to. I can.
Okay, perfect. Cool. So